addressing 19 recommendations, of which 20 statements have been obtained. The next matter is Enterprise Outsourcing Holdings, EOH Pty Ltd. There we have 2 cases currently under investigation, addressing 2 recommendations, of which the number of statements obtained thus far is 54. The next matter is South African Airways, where we have 3 cases under investigation, addressing 3 recommendations, of which 16 statements have been obtained thus far. The next matter is Mtratuzi Water, of which the number of cases under investigation is 1, addressing 1 recommendation, of which 3 statements have been obtained. The next matter is the Department of Transport, addressing 1 case, addressing 1 recommendation, and 3 statements have been obtained thus far. The next matter is Department of Transport, of the number of cases is 1, addressing 1 recommendation, and the number of statements obtained is 3. The next entity is Transnet. Number of cases is 1, addressing 1 recommendation, and the number of statements obtained is 7. The next matter is South African Airways. Number of cases is 11. Number of recommendations being addressed is 18. And the number of statements obtained is 62. So in total, we have a total of 47 cases under investigation, addressing 80 recommendations, and the number of statements obtained is 2,774. We wish to highlight to the committee that since our June 2023 presentation that was made to the committee, at which states the number of statements obtained was 2,121, and since then additional 653 statements have been obtained, which give us the total of 2,774. We also wish to highlight that we also do collaborate with SARS, and we have a few tax cases, individuals and entities involved in state captures, and where certain cases are currently pending at court. The first one is Garsfontein case 250 of 12/2018. Accused is entity by the name of Conical Chicken Pty Ltd, represented by Matludi MF. It's contravention of the Section 235 of the Tax Administration Act, as well as fraud, and the next court date is scheduled for the 13th of March 2024. Our next matter is Garsfontein case 249 of 12/2019. The accused in this matter is Frans Mangopes Lakudi, also contravention of Section 235 of the Tax Administration Act, as well as fraud, and this matter is also remanded to the 13th of March 2024. Our next matter is Garsfontein case 247 of 12/2019. The accused is Lakudi, Translation and Interpretation Pty Ltd, also contravention of Section 235 of the Tax Administration Act, as well as fraud, and this matter is also remanded to the 13th of March 2024. Our next matter is Garsfontein case 248 of 12/2019. The accused in this matter is Bond Service Telecom, represented by Mr. Slakudi. The contravention here is also Section 235 of the Tax Administration Act, as well as fraud, and this matter is remanded to the 23rd of May 2024. Our next matter is Brooklyn case 154 of 12/2022. The accused in this matter is Maslaku Jacqueline Legwabe, also contravention of Section 234 and 235 of the Tax Administration Act, and this matter is remanded to the 18th of January 2024. Our next matter is Brooklyn case 341 of 9/2022. The accused in this matter is Intertrading Pty Ltd, represented by Maslaku Jacqueline Legwabe. In this matter is also contravention of Section 234 and 235 of the Tax Administration Act, and this matter is also remanded to the 18th of January 2024. Our next matter is Polokwane case 391 of 12/2019. The accused in this matter is Mapoko Hudson Gomaswane, and the contravention or the offense in this matter is fraud, and the next court date is the 15th of April 2024. We further wish to state that we have certain cases that's currently under investigation, and here was just an overview of the case numbers and the individuals involved. It's Brooklyn case 298 of 3/2023. The offences committed here is the failure or neglect to register as a tax practitioner as required under the Tax Administration Act. And in this investigation, thus far, we've obtained 6 statements. Then we have Brooklyn case 560 of 6/2022. The offence committed here is fraud, and thus far we have obtained 11 statements. The next one is Brooklyn case 252 of 7/2023, and the offence committed here is make or cause or allow making false statements or entries in return documents or signed statements or returned documents. And in this matter, we've already obtained 9 statements. And then the final one is Brooklyn case 666 of 10/2022. And in this matter, the offence committed is fraud. And the number of statements obtained is 6. And in total, we've obtained 32 statements thus far. The Directorate also wishes to highlight to the committee that the Directorate for Priority Crime Investigation also collaborate with the National Prosecuting Authority, of which 15 investigating officers were placed on duty arrangement to the investigating directorate to continue investigating, amongst others, 140 cases that were provisionally investigated by the directorate and declared by ID. These investigations are still serving within the investigating directorate. The main case for Bosasa investigations was one of the cases declared by the ID, and at the time it was transferred to the ID, 7 suspects were already arrested. The Directorate is also collaborating with the National Prosecuting Authority through the State Capture Task Force, jointly coordinating work flowing from the recommendations of the Zondo Commission. The Task Force key mandate is the prioritization of state capture cases, focusing on operational case prioritization, as well as enhancing coordination. We also wish to highlight the number of cases that was finalized with convictions. The first one is the Free State Housing Project, addressing recommendation number 120. The accused in this matter is Mpo Gift Mokwena, and it relates to Park Road case 1158 of 11/2021. The synopsis of this case is the prosecution by the National Prosecuting Authority of Mr. Moses Mpo Gift Mokwena, who was the head of Department of Human Settlements in the Free State in 2010 and early in 2011, for contravening of sections 38, subsection 1, subsection A, of the Public Finance Management Act, 1 of 1999 as amended, and contravention of section 34 of the Prevention and Combating of Corrupt Activities Act, 12 of 2004. The outcome of this matter, the accused was convicted on one account of contravention of Section 86 of the Public Finance Management Act and one count of contravention of Section 34 of the Prevention and Combating of Corrupt Activities Act. He was sentenced to 10 years imprisonment, suspended for 5 years on count 1, and 5 years imprisonment, suspended for 5 years on count 2. The second case, which was finalized with the conviction, is with regard to South African Airways, and it was addressing recommendation number 4. The accused in this matter is Duduzile Mnyeni, and it relates to Hubrau Case 571 of 11/2020. The synopsis of this case is the prosecution of Mrs. Mayani for a disclosure of Mr. X's identity during a testimony in the State Capture Commission. The ultimate outcome is that the accused was convicted and sentenced to pay a fine of 120,000 rand or 2 years imprisonment, of which half is suspended for 5 years. The Directorate also wished to highlight our dependency on external auditors. The Directorate has established a component for financial accounting investigation, which will, once fully developed, be able to deal with the forensic auditing services internally within the Directorate. Currently, the Directorate for Priority Crime Investigation depends mostly on outsourcing. PRASA matters are amongst the matters wherein, to a certain extent, contributed in the delays. A forensic auditor was appointed in October 2020, and in May 2023, the auditor terminated the contract due to health reasons. The appointment of the new forensic company was finalized on the 1st of November 2023, and the first report is expected at the end of February 2024. The DPCI shall at all times enforce the law of the Republic without fear, favor, or prejudice, and as the circumstances of any particular case may require, in accordance with the Constitution of the law. I thank you, Honourable Chairperson.
Thank you very much, Honourable Chairperson and Honourable Members. This is the presentation from the DPCI. We will be available to respond to queries that may be raised. Thank you.
Thank you very much, General, for the report. We have a view that let's have all the reports, and then questions would follow thereafter. So I'd ask SIU for their report. Over to you, Advocate.
Good morning, Honorable Chair, and morning to honorable members and to the leadership of the DPCI and the NPA and everybody present in the meeting. And I'll do the presentation on the SIU. Let me put it in a slide mode. Yeah, I'm gonna skip certain slides because some of them are known regarding the function, the power of the SIU, the SIU outcomes. I'll go straight to the state capture matters that were requested to present on. Just to update the committee that the SIU constituted a committee chaired by the head of SIU to consider the state capture report and identify the matter that will be further investigated to ensure that there's a sufficient evidence to proceed with the appropriate action. And this happened immediately when the report of the state capture was released. The committee constituted of different managers leading different investigations related to the state capture and member of civil litigation unit. And the SIU is also participating in the following forums which were formulated to deal with the state capture implementation. That is the implementation of the report. That is the State Capture Commission Steering Committee, and that committee is chaired by the DG in the presidency. And there's also the task force meeting, which is chaired by the NPA, and the state capture case management, which is chaired by the DPCI, and the blacklisting project headed by the Department of Public Enterprise. Then the role of the SIU in the steering committee is to identify matters that are highlighted by the report and are covered by the issued proclamation, and those that are not covered. And those that are not covered, the role is to see how we can able to make sure that action are taken on those. and also to identify matters where civil litigation for cancellation of contract and recovery is underway, and those matters where SIU will institute civil litigation. And the role also is to make sure that officials are held, holding official, executive and director to account based on the evidence and finding, and making referrals to NPA where evidence points to criminal offense, referrals of evidence to state institution for disciplinary action, and most importantly, to collaborate with other law enforcement agencies on common matters. And lastly, blacklisting of company and directors and referrals to other regulatory bodies so that they do not continue to benefit after we have made finding against them. Then in terms of the State Capture Commission, the report, these are the institutions where SIU has proclamation where investigation is ongoing. They include ESCOM, PRASA, SAA, Transnet, Alexco, Denel, and Free State Department of Human Settlement. And the first one, which is Transnet investigation, the SIU investigating allegation of irregularity in the following contract, particularly on the issue of state capture, the acquisition of 1064 locomotives, and relocation of 2 OEMs, and the appointment and contract awarded to Transnet with 3 transactional advisors, that is McKinsey, Trillion, and Regiment. And in phase 2, these are the matters that are investigated. This is contract awarded to Neotel, and software solution contracts awarded to System Application Product, and an ICT contract awarded to T-Systems, and tandem crane procurement, and cranes procured from LIBA. In terms of the status of investigation, when we go through each one by one, the first one is the procurement of the 1064 locomotive and relocation of the building yard from Gauteng to KZN. Here, the allegation that we received by the SIU was that were in relation of the procurement irregularities relating to those 4 OEM, particularly looking at the price inflation and the procurement process followed. And those 4 EM, it's Bombardier, and Bombardier now is called Altron. The other one is General Electrics, and General Electrics, they've changed their name now. They are called WebTech SA Technology. Then the CSR, which is China South Rail, E-Logo Supply, and now they are called CRRC E-Logo. Then China North Rail Rolling Stock, they are now called the CRRC SA Rolling Stock. In terms of the finding pertaining to this 4 OEM, investigation is concluded, and currently we are providing support in terms of the civil matters and the referrals that we have made to other institutions. In terms of the outcome, civil recovery, SIU and Transnet brought the main application against the 4 OEM on the 9th of March 2021 in the High Court in respect of contracts to provide locomotive with the total contract value to the value of 54.5 billion. And on the civil matter number 2, SIU and Transnet have been granted a preservation order by the Special Tribunal on the 31st of August 2021 to freeze 4.2 billion held in a bank account linked to CRRC E-Logo Supply. And SARS has a preferential claim in respect of this amount due to an earlier preservation order that they've obtained. Then the next civil litigation is settlement discussion underway between SIU, Transnet, and the OEM, and have progressed well. The SIU has been consulted during the discussion, and we have provided letter of support where requested. To date, 2 settlements have been signed and supported by the SIU with the WebTech and Astrom for the recovery of 79 million and 365 million respectively. And Transnet has received the 79 million and a credit note, as well as 194 million from Alstrong. SIU and Transnet will proceed with the pending civil cases in order to have the irregular contract set aside in the High Court, and the parties will present the settlement to the court as the proposed just and equitable remedy. And still under civil recovery, SIU has noted the repayments made to Transnet of 618 million by CRRC, which was a refund of an advance payment for the MRSA, that is a Material and Reliability Support Agreement. In terms of disciplinary action, all official involved has been dismissed or left Transnet before the SIU started with the investigation. The next one, we looked at the appointment of Mackenzie, Trillion and Regiment Capital. That is the transactional advisor for 1064 locomotives. Here the allegation was that there were irregularities pertaining to the awards of the contracts to Mackenzie Consortium, and the irregularity inclusion of regiment, the escalation in the price associated with the contract, and the associate payments made to regiment. The finding is that we found that the awards of the contract was irregular, whereby in terms of civil litigation, Transnet brought various civil applications in respect of the above matters before the High Court. Regiment and Trillion and previous executive of Transnet, that is Mr. Molefe, Gama, Singh, Ramo, Sebudi, Thomas, Gianni, and Peter, cited in the civil litigation pending in the High Court instituted in November 2018 by Transnet. This matter were already instituted before SIU investigations could start. The other one is the appointment of Mackenzie still. Mackenzie settlement agreement of 870 was signed between Transnet and Mackenzie. And in terms of regiment, settlement agreement was concluded with Transnet and regiment in October 2019 for 180 million in full and final settlement. Regiment has now been liquidated, and Transnet is not able to enforce the settlement. The SIU has decided that it will not make practical sense to intervene any further in this matter, and Trillion is in the process of liquidation, which will affect the civil matter brought before the High Court by Transnet, as referred to the previous slide. The next one is Nedbank interest swap transaction in respect of the 12 billion club loan for the 1064 locomotive deal. The allegation were that the interest swap transaction were irregular and not in the Transnet's best interest. The SIU found that the interest swap transaction were concluded without the required authority and not in the interest of Transnet. In terms of the outcome, referrals, the SIU has referred evidence to various regulatory bodies, and the investigation is concluded, and we are providing support to the referrals that we have made. And the SIU and Transnet have completed the court papers to bring a review application in the special tribunal to review and set aside irregular interest swap transaction executed on the 12 billion club loan. The SIU is working closely with Transnet, who are in the final stage of mediation with Nedbank to reach a settlement over irregular interest rate swap transaction. If mediation succeeds, the matter will be resolved within the next month. If not, civil litigation will be instituted within the next 2 months. The next contract is the new TEL, which was the CCTV contract. And this one, the allegation is that the contract was awarded irregularly, and the finding is that the investigation is completed, and SIU found that the contract was irregularly awarded, and the SIU investigation is ongoing in other contracts awarded to Neotel, which include the master service agreement. In terms of the outcome, SIU and Transnet launched a review application on the 29th of May 2023 in the Special Tribunal under that case for the supply of CCTV camera to the value of 834 million. And the SIU and Transnet are requesting the court to review and set aside the irregular CCTV contract awarded. The SIU is participating in the settlement discussion with Liquid Telecom on various matters related to Transnet, which are being championed by the AFU, and has agreed to stay the review application for a specific period to allow for this discussion to proceed. The review application remains pending. However, the matter may be settled if agreement can be reached. If it is hoped that the matter will be resolved before the end of the current financial year. In terms of referrals, we have referred 49 persons, that is neutral directors, former Transnet board members, and officials on the 20th of February 2020 to the NPA. And disciplinary action, officials involved have been dismissed or left Transnet before the start of the SIU investigation. The next one, we look at the software solution contracts awarded to system application product, that is SAP. The allegation, it was alleged that SAPs paid undue gratification to alleged Gupta Enterprise, that is CAT House, and Global Soft Tech Solution to secure contract at Transnet and in the absence of any counter performance. Investigation is complete into the award of the contracts to SAP. The SIU found that undue gratification was paid to CAT House and GSS. Senior counsel has been appointed and briefed to recover the commissions paid to SAP. The SIU is participating in a settlement discussion with NPA and Transnet. And in terms of the outcome, we have referred 1 NPA referrals against 6 entities on the 16th of July 2021. An SIU team has also engaged with the Securities and Exchange Commission investigators from the American Department of Justice to assist in their investigation. Disciplinary referrals, officials involved have left the employment of Transnet during the start of the SIU investigation, and civil referral SIU Civil Litigation Unit approved the institution of civil litigation, and SIU is in the process of appointing a senior counsel. The parties have recently engaged in settlement negotiation, and it seems likely that this matter will be settled within the next month. The 8th one is the Zestola contract seeded from T-System. In terms of this investigation, the allegation is that it is alleged that the T-System alleged to have used Gupta Enterprise connection to extend the MSA by 5 years. And the investigation is nearing conclusion. The T-System is no longer in South Africa, and SIU team are considering the legal avenue available to SIU to evaluate the prospect of successful litigation in respect of the recovery. The other one is the crane procurement from LIBA. It was alleged that the procurement process to award the contract to LIBA was irregular. And in terms of the finding, SIU investigation is concluded, and we are providing support to the referrals that we have made. And we are currently in the civil litigation phase, where we found that the procurement process followed to award the 2 contracts was irregular. And in terms of the outcome, LIBA offered to repay to Transnet a portion of the contract value, and SIU and Transnet and LIBA subsequently concluded the settlement agreement on the 31st of December 2022. The settlement agreement reached was for the following: a cash recovery of 54 million for the agency fee which has been paid, and SIU and Transnet and LIBA to engage regarding the audit of the supplier development aspect of the contract to determine any further recovery to be made. The 3 parties will go to the special tribunal, and Once the matter is enrolled within current financial year, in order to set aside the two unlawful contract in the special tribunal and request the court to make a settlement agreement just and equitable. Just to stress, Chair, is just to make sure that every time when we get into settlement with most of this company where they come with the offer, we always make sure that those settlements are made a court order. We don't just settle with them. It must still go to court so that it's settled, it's made an order of the court so that they cannot renegade in terms of the promise that they made. Then in terms of disciplinary referrals, all the officials have left the employment of Transnet when we started with the investigation. However, in most cases, as we always say, we do consider them when we institute the civil proceeding. Then phase 3 matters relating to the state capture. Those are the matters that we are in the process of getting into in terms of phase 3, that is Hatch, Gobodo, Combined Private Investigation, TNA Media, and the Manganese Expansion Project. And they also include Nkonki contract, delinquents of directors, application that we are busy with, the DPE, and the GNS, that is Abalozi contract, that is Gamma legal fee and Langa attorney. So those are the matters that we are dealing with in terms of phase 3 of the investigation. Then in relation to South African Airways, as we have presented yesterday, I'm not going to go through the details here. The contract that is related to SAA, but on the part of this state capture, is the SAA working capital, that is Mackenzie and Regiment Capital. Here the allegation is the irregular award of the contract to Mackenzie Incorporated to assist the SAA in unlocking working capital for SAA. The investigation found that there was an unfair advantage given to Regiment Capital, who became a subcontractor to Mackenzie in this tender. And the unfair advantage was when Mr. Petulo Ramosebudi provided the scope and evaluation criteria to Regiment Capital before the tender was awarded. And in terms of this investigation, it's finalized. Civil recovery, the SIU facilitated the reinvestment of 14 million by Mackenzie to SAA. There was no civil litigation instituted in this matter because the matter was settled. Disciplinary referrals, we couldn't make any disciplinary referrals because all the officials left the SAA. And criminal referrals to NPA investigative directorate was made on the 31st of March 2023 against one former official. The second one is turnaround strategy. Here, the allegation is irregular award of the turnaround strategy contract. And in terms of the finding, we found that the relevant RFQ were non-compliant with the PFMA and SEM policy, and the value of contract is 170 million. And the outcome, the SIU recommended the cancellation of the contract, which brought about the saving of 130 million for SAA. Disciplinary, we couldn't proceed because members left. Criminal referrals to the Hawks was done, and that's the inquiry number there. The AFU is involved in the civil litigation recovery of the outstanding 40 million. LSG Sky Chef, the allegation is that it's alleged to have been awarded the contract under the tender number mentioned there irregularly and with the interference from the former SAA chair, which is Ms. Dudu Muyeni. And the finding is that the tender process was not followed in terms of this contract. And in terms of the outcome, the civil recovery is under consideration for the loss suffered by SAA as a result of the board's unlawful decision. And currently we're busy with the quantification, and disciplinary referrals could not be made because the member left, and criminal referrals is under consideration for the loss suffered by SAA. And board probably once quantification is done, we will be in a position to make criminal referrals. The other one is Airbus acquisition and Pembroke transaction. Here also the allegation is that Ms. Muyeni conduct in the Pembroke transaction resulted in delays in the delivery of the aircraft that costed SA approximately 800 million in pre-delivery payments. Finding is that we found that the SAA and Airbus took a decision to discontinue the manufacturing of the last 10 aircraft for the swap transaction and then they swapped the transaction with 5 aircraft. But we did find that the process that they followed in terms of making the swap based on the previous order, they didn't follow the proper process. Then in terms of the finding, we found that there is no proof that the swap transaction between SAA and Airbus was done through normal procurement processes. And the outcome is there's potential recovery of 824 million that is under consideration. And we are waiting for the quantification in order to confirm the exact amount that needed to be refunded to SA. And in terms of disciplinary referrals, we have referred one disciplinary referral to SAA in April 2023. Criminal referrals, the potential criminal referrals that is currently under consideration. The Swift Sport ground power units, the allegation is that the disposal process did not follow the applicable SEM processes. And in terms of the finding, we did confirm that. Then in terms of the outcome, civil recovery is in the process where counsel is appointed to recover the 5.6 million. And quantification currently is ongoing where we are waiting 6 outstanding invoices from SAA. And after that process, then we'll be starting with the civil litigation. Referral for disciplinary, we couldn't make it because member left, and a criminal referral was made to the Hawks, and that's the inquiry number there. The aircraft component supply tender, also the allegation is that the process was not followed in terms of awarding this contract, and that's the finding that we have made in terms of the recovery, the outcome. There's potential civil recovery against approximately 10 individual and entity. This investigation is complete except for the quantification and the flow of funds, as well as the contractual services not rendered and paid. Disciplinary, we couldn't make any disciplinary because the official left. However, criminal, there's potential 10 individual that we are going to refer to NPA for criminal action to be taken against. Paint tender, allegation is that the tender was not issued out accordingly, and we found that the tender was awarded irregularly, and the value of the tender was 19.2 million. And in terms of the outcome, this matter was concluded during the secondment period when we seconded our member to SAA, and there was no evidence to pursue civil. And disciplinary, we couldn't refer any disciplinary referrals because the official left. Then in terms of criminal referrals, we have done a criminal referral to the Hawks, and the inquiry number is also listed there. The next institution is ESCOM, and in terms of ESCOM, we've got also several matters that are related to state capture that we've investigated. The first one is Tageta Braakfontein. Thereby the allegation was irregular contracts awarded to Tageta, and we did found that the contract was unlawful and invalid in that it did not comply with the section 217 of the Constitution. And in terms of civil litigation, the contract was reviewed and set aside whereby 3.7, which was to the value of 3.7 billion, and future savings were calculated at 2.6 billion, meaning that at the time we intervened, the contract was still to run where they were supposed to pay 2.6 billion. The SIU instituted proceeding against Tageta and the business rescue petitioner for the just and equitable relief as a result of damage suffered due to the poor quality of coal that was supplied to ESCOM to the value of 734 million. and the matter is pending in the High Court. Disciplinary, we couldn't refer any disciplinary referrals because all the employee left ESCOM when we started the investigation. However, SIU is collaborating with ESCOM and the DPE, and CIPC have prepared papers to embark on the director delinquency proceeding against the former ESCOM board members. No criminal referrals were made as the ID were already investigating this matter when we started the investigation. The next one is Targeta Optimum, where the allegation is the irregular award of the contract to Targeta, and the SIU found that the contract was unlawful and invalid in that it did not comply with Section 217 of the Constitution. And in terms of the outcome, the contract was terminated in September 2016. SIU instituted civil procedure against the executive authority, accounting authority, executive management, and private individual for the recovery of 3.8 billion. And the SIU and ESCOM has been seized defending interlocutory application, which have now been disposed of. A trial date is yet to be set, and SIU is supporting the Department of Public Enterprise in the process of seeking to declare certain former director of ESCOM delinquent. Disciplinary referrals, we couldn't make any disciplinary referrals because the official left, and criminal referrals were already referred to the ID when we started the investigation. Targeta Kronfontein allegation was the irregular award of the contract to Targeta, and SIU found that the contract was unlawful and invalid in that it did not comply with the Constitution. And in terms of the outcome, the contract was terminated by ESCOM based on the SIU finding, and the value of the contract was 6.5 billion. No disciplinary action could be made. However, we are collaborating with ESCOM and DPE so that we can have the director be declared delinquent. And no criminal referrals were made as the ID is busy with the investigation. ABB International, also we're looking at irregular award of contract to Targeta. And the SIU found that the contract was unlawful and invalid in that it did not comply with Section 217 of the Constitution. The SIU files paper in the High Court on the 3rd of April 2022 to have the contract reviewed and set aside. The application is not opposed and is currently with the Judge President of the High Court in Johannesburg set down. And ABB has reached out of court settlement for the repayments of 1.5 billion to ESCOM. And ABB has already paid that 1.5 billion to ESCOM. And claim by ABB against ESCOM to the value of 1.9 billion was cancelled. We didn't make any disciplinary referrals, and criminal referrals made to supplement referrals that was already made was currently underway by the ID. Impulse International allegation was that there was alleged corrupt relationship between ESCOM and executive of Impulse, and the SIU is investigating 2 contracts awarded to Impulse International. Both contracts were found to be unlawful and invalid in that it did not comply with the Constitution. In terms of the outcome, the contract was terminated by ESCOM, and Impulse sued ESCOM for damage as a result of the early termination of the contract. ESCOM is defending the matter and also filed a counterclaim to have the contract declared invalid. SIU is actively assisting ESCOM in the defense on this matter. Disciplinary was not done, and criminal SIU made supplementary referrals to NPA as the matter was already under investigation by the ID. SAP allegation was that SAP 2016 contract was awarded as a result of a corruption. And this is the finding is that both contracts, the 2 contracts were unlawful and did not comply with the Constitution. In terms of the outcome, civil SIU embarked on civil litigation in November 2022 to have the contract reviewed and set aside. SAPS filed its answering affidavit wherein certain facts were admitted. SAP also made an offer of settlement, and currently we are busy in negotiation with SAPS regarding the settlement. No disciplinary was made, and we have made 13 NPA referrals, and the matter has been declared by ID and SIU assisting ID in their investigation regarding this matter. With regard to Denel, I'm not going to go to the background, but in terms of the matter under investigation that are related to state capture, we look at the IT security assessment services, where it was alleged that in the procurement of the contracting of the IT security assessment services, Denel did not follow formal procurement processes. Investigation is concluded, and we are providing support to the referrals that we have made, particularly to the civil litigation. And in terms of the outcome, there's a pending civil litigation between Denel and Telspace. The litigation has been stalled due to special plea in the High Court and has no jurisdiction. And instead, the matter should go to the arbitration in terms of the concluded contract. The SIU seeks to institute civil litigation in its name at the special tribunal once the ITC report commissioned by Denel is completed and received. Disciplinary, all the officials have left Denel, and in terms of criminal referrals, ID and SIU are considering criminal evidence on this matter. Next one is steel fabrication of goods and steel fabrication services, that is the Halls contract. The allegation is that Denel commissioned an investigation in 3 contracts signed with the service provider, namely Halls contract, that is Hoofesta contract to the value of 229 million, and 2 MOAs with service provider for all steel fabricated goods, open contract. The process was found to be fraught with irregularities, whereby the finding is that the service provider is under business rescue. However, this company obtained default and execution judgment against Denel because of breach of contracts and unpaid debt. The next one is steel fabrication of goods and steel fabrication services. Here we look at the Halls contract, where the outcome is that the SIU instituted a civil proceeding in the special tribunal to set aside 3 default judgment and attachment order for Denel IP trademark to satisfy a debt awarded in favor of VR Laser. Then in terms of the outcome, we have referred 2 DC referrals to Denel, and criminally we have referred 7 criminal referrals against former official to the NPA. Next one, also under steel fabrication, we're looking at the 30 subcontractors, where the allegation is that DLSA fails to follow its own SCM policy in appointing some of the companies, and the finding is that the investigation is ongoing, and determination regarding the civil, disciplinary, and criminal referrals will be done once the investigation is finalized. The next one is the chart contract, where there was irregular appointment of a service provider to deliver the Sinotrack drive train chassis to the amount of 13.8 million. And the finding is that Denel approached the service provider for the chart contract on the belief that it owned the IP. So at least 15 million of the chart contracts fund were used to settle the service providers' outstanding debt. Then in terms of these matters, the matter is currently being considered for the council for possible recovery, and disciplinary, we couldn't make it official left. Criminal evidence pointing to the Commission of Criminal Conduct is under consideration and will be forwarded to NPA once finalized. The other one still regarding the chart contract, where the allegation is the irregular appointment of service provider for the manufacturing of the Casper vehicle. Amount is 15 million. Here also we found that the process was not followed in terms of the award of this contract. Then in terms of the outcome, referral is respect of one of the service provider for the balance of the advance payment was made. and an amount to be considered is 12.7 million. Criminal referrals pointing to criminality against 7 entities and individual is currently under review by SIU internal lawyers and thereafter will be referred to NPA. And most of the officials left the employment of Denel. Therefore, we won't be making any disciplinary referrals. And also under the chart contract, also we looked at the irregular appointment of technical advisor to the amount of 9.7 million. Here, the investigation is complete, and the finding is that the contract also was not issued accordingly. And in terms of the outcome, referrals to civil litigation unit for the institution of review of the contract is under legal review, and the value of the contract is 9.7 million, and no criminal referrals could be made, and the disciplinary because the official left. The other one is the awarding of contract for the provision of legal services. Here we look at the Kampa attorney, which was appointed to render legal service, professional service to Denel without following proper procurement process, to the value of 10 million. Here we found that the contract was awarded irregularly, and in terms of the outcome, the referrals to civil litigation is under internal legal review and will be submitted to SIU civil litigation soon. Disciplinary referrals could not be made. Criminal evidence referrals pointing to the Commission of Criminal Act is under consideration, also will be forwarded to NPA. And administrative action, the referrals to book accounts of a law firms to LPC is currently also under review. And the awarding of the pilot bursary contract, this one, there are 3 bursaries that we looked at, which was awarded to 3 students. And in terms of the first one, we know we found that there was a breach of the NEL SCM policy in terms of the award of the bursary. And the first one, an AOD to the amount of 559,000 was signed, where they are busy paying it. And when we investigated this matter, SAPS was already investigating criminal referral pertaining to this matter. And in terms of referrals, we didn't make any referrals because members left the employment of Denel. And the next one, that's the next one, bursary number 2, also that we found that it was not awarded accordingly. And in terms of this here, this one, we have issued summons to the special tribunal, and the matter is currently at a stage where it's awaiting set down for the default judgment. And the next bursary, here there is no recovery because against the school due to no contract was in place between the parties, that is Denel and the school, because the money that was awarded to the 3rd student was transferred to the other student. Therefore, we are recovering all the money from the 2nd student. Then in terms of PRASA, also I won't go through the background. In terms of the matter under investigation is the procurement of royal security. Then here the allegation is that the contract awarded to royal security was not awarded according to proper procurement process. In terms of the finding, SIU found that PRASA signed the original contract with Royal Security on the 17th May 2011. The contract was on numerous occasions extended with the approval of all the former GCEO of PRASA. The SIU found that the procurement of the Royal Security was through an irregular confinement process, and the SIU concluded that at all relevant time, the appointed GCEO failed to ensure that PRASA followed a competitive procurement process in the appointment of the security services. And the total amount paid to Royal Security escalated from 578 million for the period between 1 January 2010 to 31 September 2019. In terms of civil litigation, due to lack of documentation, the SIU could not conduct full investigation to quantify any losses suffered by PRASA. The members who were responsible for safekeeping of the records and documents are no longer working for PRASA. And disciplinary referrals Officials who were involved in the appointment of Royal Security has since left PRASA and they are not employed anywhere in the public service. And 6 criminal referrals against all former GCO were referred to NPA for contravention of PFMA. The next one is the procurement of forensic investigation service, whereby the Auditor General found that the appointment of Werksman's attorney was irregular as he did not follow the competitive procurement process. And in terms of the finding, we found that there was no competitive process followed in the appointment of Werksman, but instead the board members relied on the fact that Werksman was already part of the panel of attorney that were on the database of PRASA. And the SIU found that the appointment of Werksman was irregular. Then in terms of civil recovery, none. The service was delivered to PRASA by Werksman. And the SIU is considering evidence for referrals of the 2 board members for administrative referrals. And we couldn't find any criminality in the process. Then procurement of Royal Security, another contract also, where we found that the contract also was issued irregularly, whereby in terms of the outcome, the finding is that from the analysis of the depot modernization agreement and the extension thereto, the SIU established that a total contract value of 201 million. And the SIU further established that for the period 21 July 2013 to 2 September 2016, PRASA paid a total of 266 to CIAYA. And in terms of the payments information, the depot modernization agreement and extension thereof, there is an indication that there was an overpayment in the amount of 64.8 million. And the SIU established that CIAYA is under liquidation, and SIU obtained the liquidator's report and established that SARS was the preferred creditor in terms of the liquidation, and PRASA was noted to be owing CIAYA an amount of 63 million. In terms of the civil process, due to lack of documentation, SIU could not conduct full investigation to quantify the loss suffered by PRASA. An official involved also left the employment of PRASA, so we couldn't pursue this matter further, but SARS is busy with their process. The next one is Alexco. Then in terms of Alexco, we look at the 2015 contract, which the allegation was saying it was awarded irregularly, and where we found that there was possible contravention of 217 and the PFMA. In terms of the recovery, SIU investigation is concluded, and we're busy with the referrals to civil litigation so that they can consider invalidating and possible recovery of the contract. And disciplinary employee involved in the appointment of the employment of the PSJV are no longer employed in the Alexco. And criminal referrals in November 2022, a criminal referral was made to NPA for possible criminal prosecution against the PSJV board members and management. Then the other contract, which was awarded also in 2016, we found that that contract also was awarded irregularly without following 217, and there was possible contravention of the Diamond Act, as the service provider did not have the license to sell, purchase, and beneficiate and run a trading house. In terms of the outcome, investigation is concluded. We are also looking at referring this matter to court, where we refer this matter to civil litigation so that they can able to consider it. And the civil litigation capacity of the SIU will evaluate evidence material when it receives and assess whether there is a prospect of successful civil litigation. And disciplinary referrals, we couldn't make it because all the employees left Alexco. and referrals to NPA for possible criminal referrals was done against the PSJV board and management. The other process in terms of Alexco is the quantification and evaluation, where we're looking at the diamonds, where the allegation is that the diamonds were undervalued, and the service providers which were appointed by the service provider appointed. Here the finding is that the service provider sold the diamonds on auction, and total amount of 271 diamonds carats were sold at about 1.8 billion. Some of the parcels sold below were sold below the market, and auction invited possible non-associate indicate a possible conflict of interest, and there was a possible collusion and transaction. That is what happened is that the auctioneer invited all the people that are related to him so that they can come to the auction, and that's why we said there's a possible collusion. And in terms of the status, 90% of the investigation is concluded, and there's ongoing support in terms of rendering support to civil litigation process. In terms of the finalized investigation is the one relating to the Free State that the Hawks referred to, and this one was the procurement of Diamond Hill Trading, that is the Black Hat joint venture for the identification and removal of the asbestos from houses in the Free State. The investigation is in the supporting phase, where we support ongoing remedial actions such as the referrals to the NPA, and disciplinary referrals is ongoing, and civil action is currently ongoing in the High Court. And in terms of the finding is that the procurement process in respect of the appointment of the service provider did not comply with Section 217, and due to the fact that the procurement process was irregular, the expenditure of 230 million that was incurred constitute irregular expenditure, and the amount of 208 million that the department overpaid out of the 230 million, that is minus 21.3 million, the amount for which the service could not be rendered constitute fruitless and wasteful expenditure. And in terms of the outcome, we have referred 4 referrals for disciplinary action against senior official for financial misconduct and contravention of the PFMA between June and August 2021. NPA referrals, 1 criminal referral was made to NPA, and I think on this matter, arrest has already been made. Civil action, Black Hat joint venture instituted action proceeding against the Free State Department of Human Settlement in the High Court to claim the 25 million, which has allegedly not yet been paid to them. The SIU and the Free State Department of Human Settlement therefore filed an application to review the validity of the entire contract, that is the 255 million. Application by SIU and Free State Department of Human Settlement will have to be heard first because if the contract is declared valid ab initio, it will also constitute a complete defense to the claim by Black Hat's joint venture, and the court will also be able to make an order that is just and equitable. Then in terms of the matter that are related to the state capture, where we have applied for the proclamation, they relate to ESCOM, where we ask for the extension of the mandate, and also PRASA and Transnet and the TNA breakfast. And we're also looking at the AXA, where we are requesting the extension or the issue of the proclamation in relation to this matter. And that is all from us, Chairperson. Thank you for the indulgence. Thank you.
Thank you very much. I think we have been engaged listening into the presentations. Can we allow the NPA to make their own preparation, to break for 5 minutes? And then we get back for such a presentation. 5 minutes break. Colleagues, back we are. The last presentation is from the NPA. I will give over to the acting head of NPA. Over to you, Mr. Advocate de Kock.
Thank you very much, Honourable Chair, honourable members of the committee. We welcome the opportunity to brief the committee today about the work of the MPA. We are also grateful to be in the presence of our colleagues, the leadership of the DPCI and the SIU. I again note the apology from the NDPP, who is not currently in the country. And just to introduce the colleagues today who are present with us, it's Advocate Omar Rabaji Resataba, the Deputy NDPP and the head of the Asset Forfeiture Unit in the MPA. She's part of the delegation today. She will do a presentation, part of the presentation in relation to the asset recovery part of the work of the MPA. We also have Advocate Andrea Johnson, who is the current investigating director of the MPA Investigating Directorate. She will do the part of the presentation that relates to the work of the state capture recommendations, and also relevant then to the referrals of the SIU in relation to the state capture work that has been explained by the SIU and the DPCI. Just to note, there is a lot of overlap between the two presentations that's been presented thus far by the DPCI and by the SIU. And the ID, myself, and the AFU will then speak to some of those presentations in terms of the casework, but we will not repeat once if a presentation has been mentioned in relation to a particular case. We will not repeat it. Just further to note, committee, that we value the partnerships that we forged with the critical law enforcement agencies. We work in a coordinated way as best we can. Just to remind the committee that we have a multi-agency system within this country, which means that there's different mandates in respect of the different agencies. And the strengthening of collaboration and coordination is critical to this complex work that we do. The second point I want to emphasize is that we have done much to strengthen the state's ability to do forensic financial investigations. And I think that has always traditionally been a key weakness in terms of our ability to do complex, serious complex commercial and corruption work. So a lot has been done to strengthen the Financial Intelligence Center, to be able to assist law enforcement with some of that forensic work, the illicit flow of funds. And currently, as we speak, we are also working closely with the FIC on many of the projects that we currently are presenting to the committee. As far as we will start with the ID, but just some way of introduction. To remind the committee, the ID was set up in March 2019 by the President, by creating an investigating directorate within the office of the NDPP. And to note at that stage, there was only one official in the ID, which was the ID. It was only from July 2019 that we had to find ways to capacitate the ID. There were reassignment of prosecutors from within the MPA. That was the first attempt to resource. So you basically had to borrow from other parts of the MPA to capacitate the ID. Then we had to look for investigators through SAPS, IPID, SARS, SIU. And we've heard that there are still currently about 15 criminal investigators that the head of the DPCI has, through assignment, given to the ID to assist with the MPA, with the work that we do. So the recruitment of investigators and prosecutors on contract for 3 years, additional to the MPA establishment, is something that has happened recently. And as we speak, from January 2021, 21 financial investigators are currently employed. The number may be a bit more now in the ID. And the current ID was only appointed in March 2022. And since then, a lot of fundamental work has been done to fast track and to work on the complex, serious complex investigations that are within the ID. Just also to indicate to the committee that currently in the Justice Portfolio Committee, there is a bill pending before that committee. It's called the National Prosecuting Authority Amendment Bill. The objectives of this bill, briefly, is to make the ID a permanent entity in the MPA. So that has been the concern, that the ID is not permanent. It was created through a proclamation by the President. And so the first objective is to make the ID permanent. And the second is to expand the powers of the ID to appoint criminal investigators with police powers. So this is the other current impediment in the work of the ID, is that there is no permanent capacity to be able to do investigations within the ID. And so this bill that which is a very important piece of legislation to strengthen the work of the ID, will create permanence, and it will provide the ID with the powers to investigate, so that we don't have to rely on other agencies to do the work of the ID. So with that brief introduction, I will then hand over to Advocate Johnson to proceed further with the presentation, and we can go to page 5 of the presentation.
Honourable Chair and members, my valued stakeholders from the DPCI and the SIU, and we do not say that lightly, Chair. The past year and a half, the life of the ID has been made that much easier because of the collaboration from the agencies that sit in this room. The position of the ID in terms of the staff composition has not changed. All my criminal investigators are still duty reassigned. The 15 from the DPCI, 5 from IPID, and 4 from the broader SAPS detectives. And that leaves me with a very small composition of criminal investigators who must consider all the matters arising from the State Capture Commission, chaired by the Chief Justice Zondo, the recommendations and findings of the Nugent Commission of Inquiry, the recommendations and findings of the Mpati Commission of Inquiry looking into the PIC, and as one would see on the slide currently flighted, that there are also other matters that can be referred to and have in fact been referred to the ID in terms of Section 27 of the NPA Act, and then there are matters that the Office of the National Director in turn can also refer to the ID. So there are a host of matters that the Investigating Directorate has to look at, but the criminal investigative capacity is the capacity most required, but that is minimal, to say the least. Next slide, thank you. The presentation, honourable members, we have restricted the presentation to deal with those matters that have come into the domain of the ID through referrals by the SIU. One would also note that in the main, when it deals with the SOEs, there are state capture recommendation matters that are dealt with by the ID, but there are also some of the matters that are dealt with by the DPCI. Given the fact that there are very many matters on the state-owned entities on which the Commission had made findings. So we do look at Transnet, Denel, and Eskom. These are matters that have been authorized by the ID. The next slide, Leonard. In terms of the SIU referrals, the SIU referred matters in relation to unlawful activities, as alluded to by my colleague from the SIU, in relation to Eskom, namely ABB, with regards to Impulse, Kusile, and SEP. Matters have also been referred to the ID in terms of Transnet, namely Neotel, Cutting Edge, and SEP, as well as the locomotive and transactional advisory issues relating to the 1064 locomotives and the relocation. The SIU referred matters to the ID as well with regards Denel, namely VR Laser and the Hulse contract. In the main, honorable members, the SIU has to date, in terms of referrals only to the ID, referred 8 matters. Of the 8 matters, 4 are still under investigation, that is, the investigations are in progress. 3 are already before court, and 1 of those matters is being considered for intake. If I may pause then to explain, honorable members, when the matters are referred, we consider the documentation and information that was submitted by the SIU or any other referring agency. We have to consider whether it falls within the mandate of the investigating directorate before these matters are then taken on board. If they are, the matters are then authorized in terms of Section 28 of the NPA Act. Investigations then proceed, and members are then designated and or assigned to these matters. And if I may pause to add, honorable members, in many matters where the agencies have referred for purposes of continuity, the ID has sought to designate those members within the investigations, albeit that they're being conducted in the ID space, so that we do not lose the value of the knowledge of those who had worked on the matters before. Thank you. So, the matter under intake, the one matter that is being considered, I'm not going to go into the detail. The SIU has already. It refers to a Transnet Nedbank loan swap, and it in the main relates to fraud and PFMA contraventions relating to unlawful conduct by Transnet officials or employees in terms of contracts that were not properly concluded on the part of Transnet, failure for regiments and or Trillion to comply with the FICA regulations in the manner in which they acted on behalf of Transnet before entering into the swap trades, failures to report suspicious transactions. The reason why this matter is still under consideration, the investigation itself, the preliminary investigation, is somewhat tedious and long. And unfortunately, without sounding like a broken record, it goes back to the fact that the ID does have limited criminal investigative capacity, and sometimes these matters do take much longer than expected. If we deal then with the matters under investigation that are referred to by the SIU, Eskom and Transnet, the SAP contracts, they deal in the main with corruption, prevention of organized crime contraventions, more so the money laundering contraventions, fraud and the corruption, and it looks at the improper or unlawful conduct by Eskom and Transnet officials and or its employees in terms of contracts that were awarded for the procurement of software licenses in support services to Eskom and to Transnet. The matter is still under investigation, but it is a matter that is under investigation and it's not still being considered for investigation. Thank you. In terms of the Transnet Neotel contract, again, honorable members, looks at corruption and the prevention of organized crime activities, contraventions of the PFMA. It again looks at the unlawful conduct by Transnet officials or employees in terms of the awarding of contracts, and the appointment of Neotel. Part of the investigation is the consideration that that contract was unlawful, it was invalid, and more so because the procurement processes were not compliant with the regular prescripts. This matter is still under investigation, and of course it is, as is all the state capture matters, so pardon us for the repetition of complex nature of investigation. That is unfortunately the truth of the matter. And the ID, again, is dependent on personnel or secondments from law enforcement partners for these criminal investigations. And we must be fair. All of us do have our own mandates. We all do have our own outputs. And this is where the collaboration comes in, Chair, that I am actually able to lean on my fellow law enforcement agencies to provide the necessary assistance as and when they are able to, at the same time without prejudicing the work that they have to do. And the Transnet cutting edge contracts, very similar contraventions, also dealing with Transnet officials, the contract, the appointment of cutting edge, and the procurement process, invalid, not compliant with the applicable prescripts. The matter is also under investigation. It is a complex matter, but it is under investigation nonetheless. When we look at Denel, Denel also looks at the corruption and POCA contraventions and contraventions of the Public Finance Management Act. We are considering the conduct of Denel and VR Laser. Whilst the matter has been authorized and the investigation is currently underway, the fact that we have duty reassigned DPCI officials means that in this matter the investigation has progressed considerably, and the team is working towards arrests in the matter, and that also talks to us having that collaboration and hence the hands that we actually don't have in our space. There are matters that were referred to the ID that are in court, the ESCOM ABB impulse contracts, and that matter, Chair, we will come back to. It was the matter that was struck off the roll yesterday, and we would like to tender an explanation or at least provide information, and so we will come back at the end should the honourable members have questions about that matter. The ESCOM ABB gratification also, and you would see all of these matters that we talk about deal with corruption, fraud, as well as PFMA contraventions. Here, 2 former ABB employees and their spouses received gratification from Impulse International to secure contracts, inflate prices. It was discovered that the ABB employees received large amounts of money from an entity in Dizwe Construction, owned by the late, he was a person of interest, but had since passed, Mr. Pather, and he was the sole director. The matter was enrolled in July of 2022. We are back in court on the 26th of March 2024 for further particulars, and perhaps this is then just to indicate, honourable members, one of those matters where we have money laundering charges that are part of assisting the FATF grey listing, and it is a matter where we have asset forfeiture, restraint for 545 million. And then the last matter there, ESCOM Kusile Pola Build. This matter has already been in court. It has been postponed for trial to the 15th of February 2024. Sorry, is it, am I reading? So, oops, I went one further. There's a continue. Thank you, Advocate de Kock. It is postponed for the 23rd of May 2024 for pre-trial. There had been many interlocutory applications, and again, these are the challenges one faces in matters of this nature. The accused exercise many of their rights, And by the time we do get this matter to trial, honorable members and chair, this is where we are. And so even at May 2024, it's not even for trial, it is for pre-trial proceedings. And what has also happened, chair, if I may pause to add, and I'm sure Advocate de Kock might expand on it, we do have challenges in that the matters get postponed very far out because we do not have dedicated court rolls or dedicated court lanes for expeditious hearings of state capture matters in the main. So we do fall within the normal court rolls, honorable members, in case one wonders why we give you such long dates far ahead. Then the next slide, which, thank you, that is also the matter continued. There is a SARS matter that is also on the roll for trial for the 15th of February. There is a matter that is in the regional court on the 7th of was in court on the 7th of November, partly heard. And then we do have one more matter that is enrolled at the Specialized Commercial Crimes Court, and there it is postponed to the 18th of January for the defense to consider further particulars that had previously been provided by the state, and to indicate that asset forfeiture has a freezing order in these matters, the Eskom Kusile Pola Build project of 1.4 billion. And also to just indicate, Chair, that when we talk of the SARS matters, it is a multifaceted approach that we are all using, so that if there are SARS contraventions in the broader matter, if the SARS contravention is ready, we get those matters enrolled, we don't hold the matters back, and we come together as part of the broader case strategy with the rest of the criminal matter, together with the asset forfeiture. That enables us to at least get the matters on the roll in part as part of a bigger strategy. Thank you, Leonard. Next one. This should just be an infographic, Chair. There are 122 recommendations out of the State Capture Commission that the ID has to consider. 32 are matters where specific recommendations were made. In 12, there were no specific recommendations made. Given that the mandate of the ID is to look at state capture, we were wary not to look or to ignore matters which were referred to in the State Capture Commission, but I would assume that because the Commission ran out of time, may not necessarily have made findings, but where one is able to actually investigate and find the criminal allegations in terms of the perpetrators. If we look at the life cycle status of the criminal investigations and prosecutions of matters with specific Zondo recommendations, honorable members, there are 15 recommendations which translate to 7 matters. Out of 85 recommendations, 18 matters are currently under investigation, and before court, of the 22 recommendations, 7 matters are currently in court. If the honorable members will allow me to just briefly, I have, through the course of this presentation, indicated that some of the institutional impediments, honorable members, relate to the non-permanence of the ID. It relates to the fact that the ID remains dependent on the secondment of personnel from other law enforcement partners, and this is in the main those that relate to our criminal investigations and criminal investigative capacity. There's limited skill and capable investigators and prosecutors who are equal to the scale and scope of the investigations and prosecutions that the ID is seized with. There is a shortage of specialized forensic accountants, auditors, and financial investigators in the public sector, and so at present, what we do is for these specialized services, we do have to go out on the procurement process within the Treasury regulations, honorable members and chair, and that is how we procure the specialized services, be it for digital forensic services and or for forensic accounting services. At present, we are unable to recruit and retain critical skilled and experienced personnel. not just at sustainable remuneration rates, but the non-permanence of the ID hinders the fact that the ID can go out and recruit staff. So we still have quite a lot of staff currently that are on contract, with contracts expiring as early as the first quarter of 2024. And then finally, the lack of digital forensic and data analyst capability. These are in critical cases where we have terabytes of data that have to be analyzed and processed. But may I pause to add, Chair, this is actually quite a scarce skill and capacity in terms of law enforcement across the board. And so we are all trying to fish in a very little pond for this very specialized service of digital forensics and data analysts. Because I guess in terms of the market, they're more competitive in the private sector and are able to recruit them. Finally, the criminal conduct characterized by the high degree of complex and sophisticated methods of committing and camouflaging the crimes. These have happened over a long period of time, investigations spanning multiple jurisdictions. They really require the use of international legal instruments, to which the mutual legal assistance and extraditions, both are unfortunately lengthy processes. They are outside of the ID's control insofar as once they have gone through our central authority and to the requesting country, we do rely on goodwill for them to comply. And then the last two, the length of time that has passed since the crimes were committed. The investigation commenced as witnesses and suspects are no longer available. The last commission report only having come out in June 2022. And there's critical evidential material that is not retained by many government institutions. And that has also become a challenge in terms of evidence and presenting these matters in court, as these departments do not have original documentation. And then finally, the voluminous and data-intensive dockets that run into multiple terabytes of information that require analysis and management in light of onerous discovery requirements in criminal cases. As the Honorable Committee would appreciate and understand, the accused are entitled to just about every bit of the evidence and information you have. We also have to find a way of being able to give it to them in an easily accessible manner, not always cost-effective, Chair, because the onus then falls back on us to be able to capture this information after the analysis and provide it to the accused. I thank you, Honorable Chair.
Thank you, Advocate.
Thank you very much, Advocate Johnson, and thank you, Chair. So if we continue, the next segment of the presentation deals with the work of the Specialized Commercial Crimes Unit, and these are prosecutors within the MPA that are dedicated to work in relation to the matters that the DPCI are investigating. So there's a close working relationship between the DPCI investigators and the prosecutors of the SCCU in the MPA. So if you want to think about it, it's a separate unit within the MPA, and the ID is a separate unit within the MPA. In the ID, the investigators are placed within the ID. In the SCCU, the investigators are not within the ID. Within the SCCU, they're with the DPCI. And then we have to work in collaboration with each other in terms of those investigations. So we briefly just give some background in terms of the mandate of the MPA. Ensure justice is delivered to the victims of crime through both general and specialized prosecutions. We remove the profit from crime and recover stolen funds. And critically important, we protect certain witnesses in this process. The witness protection program of the state is placed within the prosecuting authority as well. So as far as the work, the next slide, as far as the work of the SIU is concerned, just to note the point that as soon as the SIU, during the course of its investigation, picks up any evidence that points to the possible commission of an offence, that is then referred in terms of the SIU legislation to the MPA as soon as practicable. Normally the SIU will refer on completion of a report, and that report is then referred to the MPA. What is important to note, if we can go to the next slide, is that that the investigation, the criminal investigation, must still then be completed. And this is a critical factor, that although the SIU do refer matters where some of the less complex matters where with a few additional statements you may be able to prosecute. In the bulk of the serious complex work, the DPCI and the SAPS then have to investigate. So the MPA refers the matter to the DPCI or the SAPS. If we can move over. So because of the challenges that we've had before, in terms of referrals, in terms of working jointly on matters, during December 2022, we signed an MOU, Memorandum of Understanding, with the SAPS, with the DPCI and the SIU. So at this stage, even before a referral is made by the SIU, we can ensure that the investigation, the criminal investigation, is worked on. So DPCI, asset forfeiture, a prosecutor can then be assigned, particularly in the more complex work like the state capture work, to work closely with the SIU. And in this way, we believe we'll be able to speed up those investigations as well. So from our point of view, we believe that we have reached a point where, because of the close working relationships that we have with each other, that certainly we want to submit to the committee that impunity in our country is no longer a given. A lot of work is being done. A lot of work must still be done. We recognize that. But the MPA and the law enforcement agencies are hard at work to ensure that these cases are enrolled and that assets are recovered. And I think this is the important point that we will deal with later when we discuss the asset recovery. What we've also done is to ensure that there's a co-location of our investigators, our analysts and prosecutors. What this means is, on our big projects, we want our investigators and prosecutors to work together. We have found for the state capture a team of the DPCI, we found premises that are secure and where prosecutors and investigators can meet to ensure that these cases are getting better attention. We spoke about the increased collaboration in the next slide, and we also talk about the increase of the personnel that we've appointed from 2019 to October 2023. There's been an increase of 67% in terms of the prosecutors that are now available in our specialized commercial crimes unit to attend to the work. Just to note that there's a lot of commercial work, and this work of state capture, this work of SIU competes with a lot of the other commercial work that are also being dealt with by these prosecutors, that are thus on our court rolls, that are in our commercial court. And that is one of the big challenges that we've referred to, is our ability, once a case gets onto a court roll, to get that case finalized. And so the talking with the judiciary, the talking with the legal profession, how do we ensure that the cases of importance to the country, the corruption cases of importance to the country, are getting special attention on the court rolls? Surely the position cannot be that these cases must compete with cases that are important but are not as important as the cases of state capture and serious complex corruption. So those discussions with the judiciary, we certainly are engaging in those discussions through the various forums, but we want to find a way to move these cases much faster. And so that's important, moving the investigations faster and moving the cases on the court rolls much faster. So just to go through briefly then some of the work that's been reflected by the DPCI. This slide is just a consolidation of the matters. PRASA, Transnet, SABC, SAA, Department of Water and Sanitation, and the ESCOM matters. As you can see, committee, there's the number of cases reflected. Those are the ones in the court roll in the second column, under investigation in the third, and we also indicate matters finalized in the last column. If we can move to some of the specific matters. The first one relates to the SA Express case. This is one of the matters that flows from the Zondo recommendation. The way we've also organized the slide is to indicate to the committee which part of the State Capture Commission report this matter flows out of. You will see that there are a number of people before the court at the moment, including the head of this particular department. And this is a very complex matter as well. Charges of fraud, theft, money laundering, and the PFMA. We also authorized the racketeering certificate through the national director in this case. And this case is being investigated by the DPCI. Case number 2 is the asbestos case that is currently in the Free State High Court. The first matter is in the Northwest High Court. The second matter is in the Free State High Court. This is also being investigated by the DPCI, and this matter is now on the court roll on the 5th of April 2023 to June 2024 for trial. Again, if you look at that, the allocation of trial date or court time, one can understand the complexity of the work that we have to deal with. It's more than a year of court time that has already been allocated to a case of this magnitude. So these are big cases, and in order for us to effectively do these cases, it does take a lot of investigative work. And to remind the committee that we do have an adversarial system in our country, which means that when you prosecute, literally the prosecutor must be able to prove each and every allegation that is being made, unless the accused is prepared to make admissions in the court. Generally, especially in highly contested cases, accused persons make no admissions, particularly in the commercial environment. That is why it's so dangerous to compare the work that we do in our courts in South Africa with the work that perhaps happens in other countries like America. The systems are different. The way that the prosecution and the defense engages each other is different. So I'm just demonstrating the point in this matter. That is sometimes why it takes us so long to get cases finalized, in that we have to prove everything that is alleged in an indictment. We then go to the third matter. It's the PRASA matter. One person is currently before the court in relation to this particular matter. There is still other aspects to the PRASA investigation that is currently underway with the DPCI, and we have formed a project management team of all the law enforcement or the relevant law enforcement agencies to urgently finalize the outstanding aspects of the PRASA investigation. So hopefully in the new year, we will see a faster movement on the outstanding investigations in relation to PRASA. Case number 4 is also a case in relation to PRASA. Case number 5 is a case in relation to SABC, where Mr. Mtsweni, a natural person, is before the court. And then case number 6 is relating to ESCOM, fraud and corruption matter. That was enrolled on the 8th of November 2023. It will recommence on the 15th of January. We will briefly just take the committee through some of the finalized matters in the SCCU. Case number 1 finalized in the Palm Ridge Commercial Crimes Court in March 2022. The former Eskom financial controller, Mr. Moraka, and Eskom service provider, Mr. Victor Shabalala, were each found guilty of 53 counts of fraud and theft to the cost, to the value of 35 million. They were each sentenced to 20 years imprisonment. So this is the outcome that we want in all of these matters. In order to get there, it does take time. And if we are going to have matters where we have multiple accused, like some of the cases that we've indicated where we've got 18 plus accused persons that are brought to courts, it will take us more time. And so we have to find innovative ways to deal with these matters on the court rolls. We have to find innovative ways to find solutions to cases. Recovery of assets is important. And so that is the work that the prosecution is also engaged with the defense lawyers, to be able to act always in the best interest of the state and in the best interest of justice. If we can move to case number 2. This was found also an Eskom matter, fraud, theft and money laundering in the Mbombela Magistrates Court. Again, these persons were convicted, fraud, theft and money laundering, and there are the sentences, 17 years direct imprisonment, and the other accused sentencing proceedings 23rd of January. The third case is also an Eskom case. This particular individual was ordered to repay an amount of 500,000 to Eskom over 48 months. This case was referred to by the DPCI earlier. And then we also have the one PRASA matter we spoke about earlier is going to be up for sentence on the 4th, 5th, and the 8th of December. So those are the matters where there is fraud. The next slides are just the cases where we have declined to prosecute. So when an investigation is completed, Honourable Chair, the prosecutor has to assess, and in these cases the prosecutors and the investigators work closely together. Often the decision making is done by way of collaboration, but we have to assess whether there's sufficient evidence to take a case to court. And so that is part of the role of the prosecution. Our role is not just to take a case and to prosecute. We have to evaluate and make a decision if there's sufficient evidence. So in that case, we then decline to prosecute, and this is the case we refer to as the Amatola Water Board. This is one of the legs in that particular matter. There may be other matters relating to the Amatola Water Board that are still under investigation. And then the Department of Water and Sanitation, also one of the dockets that have been opened in that matter was also a decision taken not to prosecute. There may be other investigations with the DPCI in relation to further investigation. So I did mention the PRASA investigation, and this is where we're working closely with all the colleagues present, including the SIU. There are still affidavits from PRASA that are outstanding. We must emphasize that we are concerned that even in today, as we speak, we often don't get cooperation from employees of various state-owned entities. It's a concern that we've raised at the highest levels, including with the National Treasury, to indicate that it cannot be that when we are busy with investigations of this serious nature, that the doors of departments are not opened up. So to the extent that the committee can also assist us with that, that's an important issue. It shouldn't be that investigators have to go and run to get search and seizure orders. It's difficult when you have to seize equipment and files of a department. What you want is the cooperation of the DG, you want the cooperation of the officials, and when the investigators come and ask for documents, that should be made available to them. So we're just emphasizing, we're using PRASA as an example, that we're still struggling to get original documentation out of certain of our departments. And the importance of original documentation is that in court, in order for us to prove cases, the courts expect us to produce original documentation. And so where we are not able to have the original, we have to then lay a basis for admitting a copy of a document. And so it's very, very difficult to do this unless we have proper cooperation from officials. So to the extent that the committee can also add its weight to this issue, it will really assist us to ensure that these investigations all receive the proper attention, get the deserved speedy finalization, so that we can make decisions about whether we're going to prosecute and enroll these cases. Chair, so that is the part relating to the prosecutions. We now then hand over to my colleague, Advocate Omar Ribaji, to deal with the asset recovery and the final part of the presentation. Thank you.
Thank you very much, Chairperson and honorable members, and also welcome to our colleagues from the law enforcement space. Chairperson, yes, my slides start on the ESCOM matters referred to the AFU by the Investigative Directorate. The matters were referred to the ID by the SIU. So we get referrals as AFU from the SIU, from the Investigative Directorate, from the SCCU, and from the DPCI, and any other investigative agencies. So the first matter I want to refer to, it's an ID matter where 2.5 billion has been recovered from ABB. You've heard about this contract between ABB and ESCOM, and this amount of 2.5 billion has already been paid into the criminal asset recovery account. Then the rest of the cases on this page, you have seen the Kusile Power Station matters that my colleague, Advocate Johnson, referred to. We have got 5 preservation orders, as well as 2 restraint orders. So preservation is non-conviction based. This is where we've been able to establish that the property has been bought with the proceeds of crime, or the property is an instrument of crime. So we don't need to wait for any criminal conviction to finalize the matter. So as I've said, we've got the Moyo matter, 24.6 million, Tamukelo matter, still under Kusile, 9.8 million, and then we've got a preservation order, non-conviction based, and we've already filed for future proceedings to the value of 14.7 million. And then a small amount was stolen from ESCOM Provident Fund of 647,000. So there we've also already obtained confiscation order, which is the last stage. After we've obtained a restraint, and then it was confirmed, and then once there's been a conviction, we then institute confiscation proceedings. Then still under ESCOM, we've got a big matter which is referred to as the purchase of Optimum Coal Mine by Tegeta. So there we've got 2 preservation orders, one for 1.8 billion, and the second preservation order for 3.9 billion. The SIU referred to, the ID referred to this matter of Mohedin and Pillay, where we've got a restraint of 584 million, which is a Santon cast that's being handled by the ID. We also have got the Hlakudi matter, which is still part of the Kusile Polar Lake for 1.4 billion. So where you see a restraint, it's conviction-based asset forfeiture proceedings. We're going to have to wait for the criminal trial to be finalized, and then we institute confiscation hearings to determine the benefit that the accused persons have derived from their criminal activities. There's one case that's not on the list, which is an ESCOM matter, where 2 days ago we obtained a 1.2 billion preservation order, non-conviction based, where there's a big farm in the Mpumalang area engaged in illegal sale of coal. There we've worked illicit mining. So then that concludes all the ESCOM matters that we've dealt with. I think from the list that the ID has dealt with and from the preservations, I think you will notice, Chairperson and honorable members, that we've got some of the biggest restraints, biggest freezing orders that we will wait for finalization of the criminal cases to then finalize the asset for future link. Moving to PRASA matters, my colleague, Advocate de Kock, has referred to the one finalized matter of the engineer, Mr. Daniel Mutimkulu, where we have started confiscation hearings, and there we've got a restraint order of 3 million. The rest of the cases under PRASA, both SIU and I think also under SCCU, these matters are still being investigated, and we're working together with DPCI, the Director of Public Prosecutions in Johannesburg, SARS, and SIU to look into whether there are any assets to be restrained in those matters. Moving to water board matters, we've got 2 preservation orders from Mhlathuso Water Board, one for 28 million and the other one for 18 million. And then under Lepelle Northern Water Board, we've got one preservation order for R1 million, and we're still investigating further Lepelle Water Board and Amatole Water Board. Then moving to National Lotteries Commission matters, we're working together with the SIU. These are direct referrals from the SIU. And then we've dealt with 3 lakes thus far, where it's all Chapter 6 matters, non-conviction based. We've got over 21 orders, 10 orders for Leg 1 for 23.2 million. Then we've obtained 6 orders to the value of 56.3 million. And for the last leg, we've obtained 4 orders to the value of 14.8 million. We started this as a project, and myself and my colleague, Mr. Leonard Lekheto here, have finalized standing operating procedures for dealing with these National Lotteries Commission matters. There are many matters that we are still going to look into. Currently, we've got over 21 properties under freezing orders and a lot of luxury motor vehicles for the looting that occurred at the National Lotteries Commission. Then for Transnet, we've got one big restraint order, which is against Regiment's Capital. This involves the 1064 locomotives that the SIU has referred to, which is bribes received in respect of the locomotives contracts. SARS is involved, but Regiment is also currently under liquidation. So we'll wait for the criminal proceedings that are conducted by the ID to be finalized before we can launch a confiscation hearing. Then other matters, SA Express, Advocate Ducock referred to that matter. So we will wait for conviction and then we'll start conviction-based proceedings. We didn't do a restraint because we couldn't determine the value properly. And then the two restraints to the value of 1.9 billion, this is the case where Advocate Ducock referred to, where there are 17 accused before court, and we've got two restraints in place, as he had in the slide as well. Then under Busasa, we've got a small restraint in place for 4.5 million in the Vincent Smith case, and Prasa Royal Security, it's still under investigation. And then the Free State housing matter, the asbestos matter, where it was a joint venture between Diamond Hill and Blackhead Consulting that SIU referred to, we've got 300 million restrained in place. Moving along, we've got other matters as well, which is not state capture. Department of Public Works, it's a 500,000 confiscation order obtained. eThekwini Municipality, a forfeiture order for 19 million. Another eThekwini Municipality matter, the Ngobo Jakwa, we've got 450,000 forfeiture order obtained. And then the eThekwini Municipality matter involving the ex-mayor, we've got a restraint for 51 million in place, and we're just waiting for the criminal proceedings to be finalized. Amatole Municipality, we've got 23.6 million restraint in place. Vembe District Municipality, 11.2 million restraint in place, and as soon as the criminal proceedings are finalized, we'll do a confiscation inquiry to determine the amount of benefit that the accused would have obtained in the matter. As far as the various SAA matters are concerned, we don't have any freezing orders in place, but we are part of the team that is investigating these matters. We're working with DPCI and all other colleagues. There are matters where SIU, like the Lottery Commission matters, refers directly to AFU, and we've got finalized matters, confiscation of forfeiture orders, 56 matters to the value of 132 million, and then we've got 50 preservations that they referred to us to the value of 1.8 billion, and we have made 98 million recoveries, which is money in the bank, and this is where the matters were referred directly by SIU, like the National Lottery Commission, as I've explained. Thank you, Chair, and honorable members. This is the end of the presentation on recoveries.
Thank you, Honourable Chair. I think that is the MPA presentation. And just to emphasize again that the strength of how we are working now is that we work together. And that MOU that we've signed is pulling the work together, and we've created project teams. So when we come back in the next round to the committee, we will demonstrate more progress. So thank you very much for this interaction. Thank you.
Well, thank you very much for the presentations that have been made by various parties that relate to a number of activities, actions taken, progress on such, on matters which are still in the pipeline. So colleagues, here are the reports. We took about 3 hours on those presentations, which indicate the extensive nature of the presentations that have been made. Are there any areas of questions, concerns, contributions? Honorable van Mierlen.
Thank you very much, Mr. Chair, and I want to thank you for the presentations. As we commence, before I got into politics, I was an attorney and I have worked in the criminal sphere, so I do understand how the system works. I've got several concerns in general that I really want to raise about what we're seeing here in this matter in the South African reality. So what I'm picking up is there really are enormous delays in the system. When we have a matter that has taken 11 years, we on these lists regularly see matters that take 5 years, 6 years, 4 years. I do understand that there are a multitude of different agencies working on these matters, but there are internal processes with disciplinaries, that there are criminal proceedings, that there are civil proceedings. But what we see again and again and again is that people allegedly commit very serious fraud and embezzlement within an organization. By the time the investigation has happened, they've left. So then there's no disciplinary proceedings. Hopefully there are criminal proceedings, though it does seem to take forever, and I'm going to get back to that. And of course there can then also be civil proceedings against those people. But in general, it really appears that the length of time it takes to do the investigation is becoming one of the big stumbling blocks. Just yesterday, we saw the situation with the cocoa matter, where it was thrown out of court on the basis that it's now been sitting for 5 years before it got to where it was yesterday. So it had nothing to do with the merits, but it had a great deal to do with the technicalities. So in South Africa, we talk about justice delayed is justice denied. It's obviously not as simple as that. There's a lot of case law revolving around what exactly that means. And it certainly seems that if somebody is not charged, it doesn't seem to apply as much as when somebody is charged, because then obviously justice has to be relatively swift. But I'm really concerned that in and above everything else, the issues with the courts, the delays with the rolls, the defense that can be brought, the Stalingrad defenses that can be brought, people going abroad having to be extradited, whatever the case might be, I'm really concerned listening to all these reports that a very large part of the problem is the amount of time it takes to actually get investigations court ready. And one can't just say it's the court roll. So if we could please hear what is being done about that, what the problems are with that, and a reassurance that the investigations are taken seriously. Because right now, an enormous amount of them seem to exist on paper, but the reality is that there are no ramifications. I mean, so much so that it really seems that you can join a national entity, do pretty much what you want, and then leave. And chances are you'll be just fine. And that's something we really, really can't have going forward. Thank you.
Honorable Liz.
Thank you. There's a long queue of people wanting to ask questions this morning here. Sorry, Mr. Chairman, I also did promise General Labia that I wouldn't ask him about a case I've asked him about every time I see him since 2017. So I'm going to keep my promise. I'm not going to ask him about that. Mr. Chairman, the point is well made in terms of long delays. No, I'm not. and it seems quite clear that there's a massive resource shortage amongst the various agencies, and that really is not I mean, it's obviously a concern there as well, and we'll hear from them what they think can be done. But, Mr. Chairman, it's probably more of a political thing. I mean, the country's in financial crisis, and we have budgets being cut. But these budgets are budgets that shouldn't be cut. These are institutions which are recovering money, hopefully back into the budget and not into someone else's pockets to be raided again. And yet we don't give them the resources to do their job. That's the way I see it, and perhaps we'll hear some confirmation on that, Mr. Chairman, because 3 hours of presentation about a very small fraction, really, of the criminal activities taking place in our country, it's mind-boggling how much work there is to deal with criminality in our country. I do have a slight difference of opinion, although I understand the motivation that important cases must be prioritized. But at the same time, even the unimportant cases must also get the priorities they deserve. And so it's quite a difficult conundrum that you have to deal with because you have limited resources, as I understand it. I'm curious about the ID situation. You did mention that you try and, I think if I was listening correctly at that time, that you've got people seconded to you, and before they go, you try and finalize issues. But I mean, if you've got temporary or non-permanent people, and these cases take so long to deal with, you're moving from one person dealing with the case to another. I assume that's a disaster in terms of getting a conviction at the end of the road. So, yeah, I don't know how you deal with that without making it permanent. But the whole purpose of the ID was to deal, as I understand it, with state capture, which was supposed to be finished. It's not happening anymore, is it? Or is it? You don't need to answer that question, but if you want to, you can answer it. And whoever. The one, there's an interesting case that involves a previous chair of this committee, a person who, and Ntombi's looking at me now, and I think she might know who I'm talking about, who was highly regarded, but clearly shouldn't have been. And you referred to I don't know, I think it's a preservation order, as being a small one of 4.3 million, 4.5 million. And I suppose in the big numbers you deal with, it is a small one. But as a member of parliament, that's a huge amount of money. We get paid probably a great deal less than all of you sitting across there, but we won't get into that discussion. So what exactly has been preserved in that particular case of Vincent Smith's that amounts to 4.5? Because that then leads me on to the others. All these preservation orders, and are they backed up with solid assets or cash in the bank, or are they just orders and you've still got to go and make attachments? That I'm curious about that. It's just probably not that important to the general picture, but for my own edification. I don't want to go into any more detail about the speed at which, or the lack of speed which it happens, because I think it's quite a big question that needs perhaps some intervention from your agencies, but perhaps a much bigger intervention. Thank you, Mr. Chairman.
Well, thanks, colleagues. I think if you get on the questions or comments referred to yourselves in terms of the presentations, one big one is a stretch of time. The second one is based on value. Who classifies these cases? I think Honorable Lies is making reference to importance, the importance of the cases. That classification, which might lead into somewhat leave other cases because they're not important. You see, so then it becomes problematic. I think that's his a reference on such. You know, throwing a case out is a technical process, and I don't think it's our intention to delve on such technical matters. But there it goes deeper into the fact that is there a situation where you rush to get into these kinds of charges without a conclusive nature? That because if you're talking about justice delayed, justice denied, goes crossways, you know, and it's a matter of big consideration, and to yourselves, it eats into your credibility, even if it's something which gets into a short-term effect, you know, as if you are acting because there's some pressure which is applied without your consideration on the technical matters which drives you to take a case to courts, you know, and that then create a sense of a justice system which is somewhat cracking in a way, something which ought to be avoided. You know, it might be when you arrive at such definitions in terms of the cases you handle, you as well get some form of being pressured to act without properly cooked, you see, form of taking a case around these matters. You see, we asked a question sometime, which was in relation to our hearing here that we just had on the ESCOM matter. When we asked General Ibe about on the bulk evidence referred, well, in brackets, to them in terms of what we were looking into. And he says, coming back to us, no, those are not statements. Those are not signed affidavits. So even if you start to make some kind of investigation, the drive would have to make a lot of work around those matters, you know, which then begins to say, we in the public, we might see these things as if we must get there and pounce into action on these matters because we feel that there are these big monies lost and therefore you must quickly jump on these matters, you know. So with that kind of pressure which comes from various angles, you're bound to, if you are not so resistant. I was watching him sitting there saying, no, we can't get into that. There's no statement that we can't do that. So we have to do A, B, C, D, E. So that sort of resilience in terms of acting into these things. So I'm asking that question to that a kind of comparative. And you know, if you look into the institutions themselves, because of your own defined roles, you might be led to believe, as it is the case, that one institution is doing more than the other because there's these kinds of strides which are made. In this instance, SIU was the powers they have in terms of civil litigation and their referrals into the matters they handle. So there's a multiple of actions which come with that, and then at the same time there will be referrals. So the two of other institutions here are handling those referrals. And in some referrals, you'll take a decision, no, I refuse to prosecute here. Though there's been reference to yourselves on the matters which might have that outlook that you must prosecute. Because to weigh on these matters, when the decision has been taken by referring to yourselves, it carries that kind of a view which says preconceived, you must act, someone must act. And then the decision there, is it that made singularly or is a collective decision that if I've referred this matter to you, we act together to decide as to no, we've somewhat found out this would give us tall order to prosecute on this kind of matter, and therefore you don't prosecute on a particular matter. And then lastly, is that with recognition of the actual difficulty that is a number of state capture referrals or a decision referred that further investigation has to be conducted, this and that should be done, and this and that, you see, should somewhat be done. So it's referred to various state institutions to deal with those kinds of matters. So the listing of them in terms of your attendance assists to determine the value that goes into that kind of a referral by those who have somewhat decided on those matters. And the pressure on you is that because there's been that decision for the recommendation to yourselves, that regardless, you must push to act on these kinds of issues. So to us, the story of your capacity becomes critical. When you say we don't have capacity, we are reliant on this and that to support us on this kind of matter. And if indeed you are given that task, those responsible to refer or to throw to yourselves such tasks, the expectation is that there must be some form of a balance in terms of the capacity to pull into those kinds of matters. Are there any time limits that goes with such referrals so that you should indulge on such kind of matters, knowing very well that here is the time, that which is the outlook to deal with these other matters. So I think those are the things that we must deal with. I think Honorable Lies has spoken about the budget-related matters, which might as well bring in another element in as far as the delays are concerned, maybe as well on the qualitative nature to pull with this kind of work. So we must somewhat ensure that work goes on around these things. And unfortunately, while you are pushing to do these others are left behind. He says, I'm not going to ask you a question about staying off. You see? And the people, once you pull with others, or once you are pushed to pull with others are going to remain behind. And somewhat, if you balance up the actions, the huge amounts of monies here lined up on various companies, big companies. We don't want to see actions ending by recoveries only. The criminal element should be propelled as well within such ambits. They can't indulge on acts of criminality and run away, and then those who fall victim would only be those who might have been some beneficiaries through that kind of process alone. You see, so they must pull somewhat the load together. We must see justice somewhat done one way or the other. So I'll give a general your first bite on these comments, and we aligned as such SIU and then the NPA.
Thank you very much, Honorable Chairperson and Honorable Members. With regard to the first questions from the Honorable Van Mienen regarding the delays in the investigations, indeed it will appear that there are delays, whereas there is a lot of work that is being done. It's just that the volume of work might be more than the officials can be able to handle at a time. So if one was to look at the information that I provided in the opening remarks, that we have got more than 19,000 of these cases which are by nature national priority offenses. And we have already placed on the court roll more than 11,000 accused persons. And if you look at the nature of the cases, some of them which have been referred to in the attachment of assets and the like, you ask cases like, we will say we have got one VBS matter. You look at the content, we have got more than 29 accused persons and who are serving before the various courts in the country, and we have not yet completed. You look at the number of statements that have been filed in those matters, it's more than 1,000 statements. You look at other matters like Durban waste, solid waste that they referred to with regard to the attachment of the assets, some of the former mayors and the like. We may be saying that it is one matter, but you have got more than 2,786 counts. So it means that, in fact, you have got more than 2,000 cases in one. And you look at the number of statements that have to be filed in those. You have got more than 1,000 statements that have to be obtained and filed in those. So that's why even the trial will be taking a little bit longer. And then you look at the number of accused persons that are actually charged in that one case, which I think you'll be seeing the delay when it comes to hearing these matters to be finalized, because one accused might not be coming the next time, the other one wants a new lawyer, and all the like. This obviously causes some delay. You have got, as an example, you have got a matter of Modak, the racketeering gang in the Western Cape. People might say one matter of the Modak gang. You have got 8 accused persons that are serving before the court with more than 3,000 charges. So in fact, you are dealing with more than 3,000 crimes that have been committed, to put all these things together, it means that you have got to be approaching several witnesses at different places. And that would appear that it is taking time, because you can't do, as an individual, one investigator. It means that you have got to put more investigators in order that they can be able to finalize quicker. So those I'm just citing as an example of why there appears to be some delay. It is because of the complicated nature of the work. Some, they have already indicated the willingness of some of the witnesses to come voluntarily, which is where you have got now to go to court to go and utilize the Section 205 to compel those who are reluctant from cooperating, to force them to cooperate. With regard to the questions raised by Honorable Lees, indeed he have fulfilled the promise of not asking some of the questions. The concern regarding the resources, we have been indicating, as the ID and other colleagues are indicating, I think that the resources that we are having are not matching the workload. We are currently operating at 53% capacity. And as you can see, we are prepared to be cooperating, but I think that there is a need to add on the resources so that we can be able to finalize more cases. With regard to the last matters that have been raised from the chair regarding the prioritization and the classification, which also goes to the Honorable Lees, I think that we would like to be dealing with all matters on a first-come, first-served basis. But you will also realize that the expectation is that certain cases need to be prioritized more than others. One case might come today and people will be asking questions, no, we want to hear that one. How far are you with regard to that one? So an individual may have lost 500 rands, and then that particular matter to that individual is important to the other one who may have lost 1,000,000 rands. So prioritization, we do that because indeed there are certain influential areas where you shall have to ensure that you deal with that speedily. So there is a criteria that we have built on to say that what is that which inform the prioritization is various aspects that we look at, the value and then the complicated nature, the nature of the individuals that we are dealing with, the standing in society and the interest of the public. So those are some of the things that we look at in terms of prioritization, which to a certain extent means that we classify this matter as requiring more attention as compared to the others, such as the matters coming from the State Capture Commission. By its nature, it requires that you shall have to prioritize these matters. So that, I think, is part of those that suggest that some of the matters seems to be receiving more attention and are, as a result, prioritized above others. So those are the comments that I needed to be highlighting on. Thank you, Chairperson.
Thank you very much, General, for such. I thought I would as well go into the area of omission from your side. On you've spoken to us about ESCOM, water and sanitation, South African Airways, Transnet, South African Broadcasting Corporation, DENEL, and there is one outstanding matter which you're supposed to report on us as highlighted, the Skills Fund.
Maybe
If you look into slide 4, your slide 4, which highlights areas of reference. But while we are looking into it, can we get SIU if you've got anything to respond to?
Thank you, Honorable Chair. We have noted the comments from the committee member. And I think, like we have indicated, that the signed MOU with the Hawks, the NPA, and the subs is really making sure that we clearly corroborate, and it's really enhancing the way we deal with matter. As we can see, that there's quite progress in terms of how we deal with some of the matter. And particularly on the SIU side, on the matter of classification or prioritization, with us, Chair, we make sure that every matter is allocated an investigator, or matters are dealt with. And I can assure you that we'll never come to a point where we say we are satisfied with the resources. We'll always need the resources, and because you can understand from SIU point that whenever proclamation comes, it doesn't come with the resources. We have to look internally within what we have to say, who can we take to deal with such proclamation. So from what we did, we tried to improvise by making sure that all our investigations are done in a project base, where you were able to see where the members are and which members has time available that can be allocated to a new matters. And as and when the member is waiting for bank statement or other things, you are able to utilize him for other activity. And also the use of data analytics in order to make sure that we speed up investigation and we identify the red flag quickly so that matters can be finalized in time. But otherwise, we're quite happy with the way things are done, but we note the issue regarding the timeline and speeding up of matters. Thank you.
Thank you very much. Are you ready, General?
Thank you, Honorable Chairperson. In this regard to what is appearing on slide 4 on the National Skills Fund, in slide 37, we will be indicating that there is that matter that we are handling. Indeed, that is under investigation. There are already 110 statements that have been obtained with regard to those complaints regarding to the National Skills Fund. So it has not been put in detail, but that which is reflected in slide 37, there is the investigation that we are currently doing. Thanks, Chairperson.
Okay, thank you very much, General. With a value of 2.5 billion, is that the case?
That's correct.
Yes, or it's not as yet, but dealt with in depth in terms of knowing the nitty-gritties in terms of numbers involved and all that stuff. So you're still in the initial phases of the investigations.
Thank you, Chair. What I can just indicate on the matter, as we have indicated that amount, which is 2.5 billion, it's about 10 different projects that were funded by the National Skills Fund. But the investigation is still done under one case, and once it has progressed, then they might be splitted to different cases. But it pertains to 10 projects funded by the National Skills Fund. Thank you, Chair.
Thank you very much. Thank you very much. To the NPA, are there any matters that you want to respond? Okay.
Thank you, Chair. I will ask Advocate Johnson to respond to the questions around limited resources in the ID, and then Advocate Rabaji can respond to the question around the preservation order in the Bosasa matter. And if there's any other matter aspect, you can also respond, and then I'll take the last. Thank you, Chair.
Thank you. Honorable Liz, so where the collaboration has worked in terms of when we get to the point of the end of secondment, we have to consider new people. The collaboration with the DPCI and the National Police Commissioner has been such that when I got to that now at the end of August, I was able to engage them well before the time, discuss the challenges with having any of those members being removed, and both agencies were kind enough to extend the secondment of the existing officials that were already in the ID space. And for that we're eternally grateful, or else the fear you had would have become my reality. I would just like to respond with the COCO matter. The COCO matter was only enrolled on the 27th of October 2022, Chair. That was late last year. Appeared again in February 2023. At the time, we indicated to the court that we have 2 reports that are outstanding, a digital forensics report and a financial auditor's report. Matter was postponed to September, and the court then said the court will hold an inquiry because these are now delays. Unfortunately, the volume of the work, we couldn't correctly estimate to the time it would have been done. And we also had to work through the procurement process of Treasury in procuring the 2 specialized services, which is a digital forensic expert, as well as the financial auditor for the 2 reports. That is how that matter was struck off the roll. Safe to say that we are meeting tomorrow so that we get all our ducks in a row, make sure that we expedite those reports for the matter to be re-enrolled as soon as possible. It is not one of those matters where we can sit back and say, oh, well, it has been struck from the roll, we'll see what to do. There's things to be done, and we will give it the attention that it requires. And if I may lastly then, through you, Chair and Advocate de Kock, Chair, at least in the ID space, there is no rush to enroll. However, we are mindful that the public wants justice. So that is what we keep at the back of our heads, but no one rushes us to enroll. So we are mindful that South Africans have an expectation, and so when we consider matters, we are also under no pressure to enroll, but what guides what we enroll and how we enroll, we look at those persons who really did the most harm to our constitutional democracy. Which of those state capture matters do we put on now to deal with that impact that was made to our democracy? And that is how we've been able to deal with the state capture matters to date. I thank you, Honorable Chair.
Thank you, Chairperson. The question was asked by Honorable Member Liz as to whether these preservation orders are backed up by actual property or assets, or it's just a, an order, a piece of paper. So I happen to be, having the court orders for the national lottery matters that we're doing with the SIU. So in the order that I referred to of the 11th of April 2022, we've got a lot of property. We've got property in midstream. We've got farms in Limpopo, Louis Trichardt. We've got houses in Bryanston. So, and then the luxury cars, we've got the BMW 420i. We've got 2 Ocean Basket franchise. at the mall at Carnival City. So it's actual property of value. We've got a Porsche, we've got a 7 Series BMW. So we appoint a curator and he does sort of an assessment, a value. So most of the time, we are not far off in terms of, if we say we've got a value, a preservation order to the value of 23 million, it's exactly that. If you also look at the asbestos matter, the 300 million, which SCCU is prosecuting, and we got a referral from SIU, we've got properties in Bryanston, most expensive property here in Cape Town and in Durban, and then we're able to get a confirmation of the restraint order on the return day for exactly that 300 million in consultation with senior counsel who was representing the accused in that matter. So they are generally backed up by other cash, actual property, farms, and other assets. And then for the Optimum coal mine, the mine and the allocation to export coal at Richards Bay were also valued by many evaluators. The coal contracts were valued. We had an expert from London, and those are the reasons why we've got a 1.8 billion preservation order and the other one for 2.8 billion. So there's valuation that goes into those properties. As far as the case of Vincent Smith is concerned, I wouldn't remember off by head what constituted the 4.5 million, but Chair, I can send a written response and attach the court order if it's permissible.
Mr. Chairman, just a quick question. So the Porsche has been attached. Who's got the keys?
The curator.
No, fine. Colleagues, do you still have anything to say before we close? Honorable, yes?
Mr. Chairman, I've just got one curious one that I did make a note of and I forgot to take up. The SIU we see regularly, so I could take it up another time, but by that time I will have forgotten. The GPUs that were sold at a very low value, SAA, and then rebought or hired back and so on. You say the SCM process was not followed. And why I'm asking that is that every time we raise the question of the sale of SAA, not just a piece of equipment in SAA, the response I get is, well, it's not part of the PFMA or any, there's nothing to guide it. So if there's something to guide the sale of machinery, surely there must be a same process to guide the sale of shares in the company, or am I way out?
You see, Honorable Police is asking a number of questions in one. So if you attempt to answer the question, answer it.
Thank you, Honorable Chair and Honorable Member. In terms of this aspect, I can always go and check, but from what I know is that there's a disposable policies in terms of every organization when you dispose of some of your asset. So there's a policy, there's a procedure that you need to follow. And I think also it all depends on what type of asset is it, because you can't just resell it. And so in this aspect, I think they didn't follow the process that they needed to. And also, even if when you dispose, you appoint either an auctioneer to be able to sell those assets, you need to follow a process to appoint an auctioneer that is going to dispose that. But if you don't follow the process, you just go around and pick at somebody else, it means you didn't follow the process. So there's quite a number of issues there. Thank you.
You got your answer. No, fine. No, thank you very much, colleagues. Do you want to say anything, Advocate de Kock? Okay.
Chair, there's something hanging in the committee around Steinhoff, and I think that because the name has been raised, we must say something about it. To say that the Steinhoff matter is receiving absolute priority attention as we speak, it's at an advanced stage of preparation. We are in some sensitive discussions with some foreign jurisdictions, which I think we can mention in the committee. And we hope to demonstrate some action in that case very soon. I just want to emphasize that is also a priority case for the MBA, for the DPCI, and that case is getting attention, because you raised earlier that some cases may fall off the radar because of other work. Just to say that that is not so. Then on the second issue that you also raised, Chair, around prioritization, it's not a question of saying this case is more important than that case. All cases deserve attention on our court rolls. The reality is that there is congestion on our court rolls as well. And the reality is that there are limited resources. But of course, all of our agencies do the best that they can to give attention to all matters. But out of all of those matters, you have to weigh it up in terms of prioritization. And the factors that you would take into account, the first one of critically is the public interest. The public interest is important. Where funds have been stolen from the fiscus, those are very, very important matters that you take into account. It has been mentioned the impact that has been done to our country, to our democracy. You've got to take it into account. And we want to build confidence of the public in our system, despite all the challenges. And so the cases that we feel will also assist us to build public confidence, like the Steinhoff case. Lots of questions being asked. So that case, we must demonstrate that those matters are getting attention. And then finally, the value involved is also a factor, a critical factor that has to be taken into account. Chair, you also mentioned about the decision making. How does it happen? And so all of these matters where the prosecutor and the investigator are working together is what we call the prosecutor guided investigations. We would want decision making to be done in a collaborative way, and that happens in the majority of cases. There are cases where prosecutors go off on their own and make the decision without involving the investigators, but General Bay is quick to send us a note to say, please let us know what's happening in this matter. But the general rule is that the investigators and prosecutors would decide together. But remember the mandate of the prosecution, the prosecutor must make the decision, ultimately. So where there's disagreement, then of course it is the prosecutor's decision that should be made. And that's what the law says, and that's how we do our work. And then on the matter of yesterday, Advocate Johnson has indicated some of the challenges. I think it's important just to note that the case of the complexity of that particular matter and the seriousness, that hasn't been on the court roll for a very long time. We disagree with the ruling of the magistrate in that particular matter. The state did argue against that, and the law makes provision for other remedies, including postponing a matter for final conclusion of the work. And one of the critical aspects the court need to take into account is the seriousness and complexity of the case, as well as the public interest in a particular matter. So we just want to emphasize that in our view, and in my view at a personal level, the case could have been dealt with differently. They didn't need that kind of outcome in court. And so the MPA will do all in its power to ensure that that case is dealt with appropriately. We will work with the ID to support the ID and to ensure that if there are any lessons learned from the particular matter, we will take those lessons. But just to say again to the committee, Chair, I think you raised it, the impact of matters being struck off the court roll. As you put it, maybe the case is rushed. But we don't rush cases, but there are certain challenges that arise in any serious, complex investigation, even when a case is on a court roll. And so the judiciary has final determination, has to weigh up all the different rights. But in our view, a remedy of striking a case of a court roll is a drastic remedy. And we certainly believe that there were different options that could have been exercised in that particular matter. So, but we leave it at that, and we will deal with it appropriately as we go forward. But I think it's important for the committee to note that we take it very seriously, and we'll look into the matter very seriously as well. Thank you. That's all we have to say.
Okay, in close, do you have any comment, General?
Thank you very much, Honorable Chairperson. I think in closing, one can just say that the members in the DPCI are committed to their work. On a daily basis, if one is to check on the media, one will see the product that is being put on the table. Every day, there is a court process elsewhere in one of the provinces. There are always arrests that we execute. Over and above dealing with a criminal investigation and the arresting of the suspect, we also have, since 1996, an additional aspect of also looking at the proceeds of crime. That is where part of our investigators will be looking at a civil part, the investigation of the assets, so that jointly with the AFU, we can be able to deal with the assets and the instrumentalities. So it's not only criminal investigation. A portion of our members are looking at the asset forfeiture investigation. So we have got a section within the DPCI that looks at that. But the committee should rest assured that there is commitment on the part of the investigators, and indeed we have taken the note of the comments, and then we will continuously, in collaboration with our colleagues, improve on the production that we put on the table. Thank you very much, honorable members.
Well, thank you very much, honorable members, for contributions in the meeting, and we thank the parties involved in terms of their presentations and commitment into doing more, looking into the various amounts presented to us, which are currently have somewhat evoked such a kind of action towards looking into both civil litigations and criminal-related matters, recoveries, and all those relevant remedies to ensure that in whatever form that those who are involved in criminality, fraud and corruption are somewhat followed in observance of the legal supporting aspects in our law. And doing so, we ensure that the possibility of recoveries is somewhat anchored, which could be a further benefit in terms of the fiscus and enhancing your own role through those recoveries. Yes, you face a very tough, difficult situations, and working together might somewhat strengthen your abilities one way or the other. So thank you very much that you have indicated that the matters that have been asked for, there is relevant action on them. And our side will continue to interact with yourselves because where there is value, where there is money, the committee sharpens its own eye to look into how can we at best do to recover and make punishment on those who are somewhat involved, of course, in high observation of the law. As a constitutional state, everybody has the rights. The victims have the rights, the perpetrators have the rights. So in dealing with all these kinds of actions and activities, we get some kind of joy when at the end of it there is somewhat a resultant action which has been caused by such action. So thank you very much for your collaborative exercise and the very undertaking to do this kind and scope of work going forward. We'll indeed look forward to see the finality of some of the matters which we have spoken about. Thank you very much. The meeting adjourns. I haven't had any further instructions from table. The time is 12:54.
Mr. Chairman, we were contemplating, given our numbers, a vote of no confidence, but we've reconsidered instead a vote of thanks to the chair.
I'm advised that lunch is served closer here. So I think Mr. Lungisa Palfo responsible for that invitation. Thank you very much. We adjourn. Thanks, Honorable Yes.